I did a consult today for a client with 9 children and 19 grandchildren, and I want to say 8 great-grandchildren. The client, the prospective client, it's an actual client now, is not an elderly person. It's an older person, but so many children and grandchildren and great-grandchildren. The question came up. One of this person's children had predeceased this person, right? So a child of the will maker. I'm going to use this as a will client. It could have been a will. It could have been a trust. Might be both. Let's use will. What's a will? A will says, hey, upon my death, if I have this item, this thing, this property, this account, this money, anything that I own, right? The stuff from my life. If I own that at the time of my passing, this house, I want it to go in a certain way. That's what a will basically says, right? This person, one of this person's children, predeceased. How do you handle that? What do you do in terms of, do you keep the percentage that child would be entitled to? Do you keep that percentage and give it to the children of your deceased child, or do you not? So 8 children, 1 passed away. What should this parent do? And I'm only framing it like that as a point of conversation. There is no should about it. The person makes their own decision, and it could be divide everything in 7 ways for the 7 surviving children, or it could be let's divide everything in 8 ways. 7 for the children that are alive, and a 1/7 share to the children of that deceased person. In effect, the grandparent is giving to the grandchildren, but only in the percentage that the parent would have gotten. So fairness is in the eye of the beholder. There's no hard and fast rule. Right? You can disinherit children. So this person doesn't have to leave to any of the surviving children. All of the assets of this person can go to a charity, can go to a hospital, go to a friend. It's up to the individual person. That's the estate plan for this person. It could be all, some, none, or any other percentage. It doesn't even have to be an even percentage. By way of conversation, I'm using for 8 children, 1/8, or 7 surviving children, 1/7. Doesn't have to go that way. The favorite child could get 50%, and all the rest could share 50%. The several children that were supportive of the parent, say 4 children really helped out this parent, maybe they receive all of the benefits of the person's assets. And the ones that haven't been around, haven't helped, haven't been in the life of the parent, they could go hop. 4 ways that I can help you and your family. 1, get an estate plan, a trust or a will, or at least information leading to you using beneficiary designations, perhaps even a deed transfer on death just went into effect. Well, it's not in effect. The law was just signed. That might be an option for you. Beneficiary designations, joint accounts, wills, or trusts. That's number 1. 2, watch my videos. You can learn so much from me teaching you by video. 3, avoid nursing home poverty. Plan in advance with an irrevocable trust. And 4, what's 4? Did I write down 4? Yes, come to a workshop. Come to an estate planning or guardianship workshop. I do 2 a month. I discuss for guardianship, incapacity planning. No, that's in the trust. That's in the estate plan. For the guardianship, from the filing of a petition, the alleged incapacitated person, all the way through judgment. I discussed that in a webinar. And for estate planning, I go over advanced directives, healthcare proxy, living will, power of attorney, HIPAA, and I discuss probate, a probate avoidance trust, and a Medicaid asset protection trust. All of that and more. A durable power of attorney, a useful document, an important document. The person that makes the power of attorney is the principal. I may make it for someone's right, so I'd be the attorney. But in this scenario, the principal is the person that would like to give someone else the ability to work on my behalf. So I can give my wife, I can make a power of attorney, and I can make my wife request it from her, ask her if she would like to be my agent. I'd be the principal, she'd be the agent, and she could do things for me. However, what could she do? She can go to DMV for me. She can go to the bank for me. She could deal with Time Warner cable, Spectrum cable, Cablevision, any cable TV company, Geico Insurance, State Farm Insurance, right? Any of the insurance companies, the IRS, deal with issues related to the property that we own, or a bunch of things. Now, her having a power of attorney does not prevent me from being able to go into my account. I can go into my account, I can go to DMV, I can go to the insurance company, I can go to the property courting agencies, I can go wherever. Her having the power of attorney does not limit me. And that becomes an issue sometimes when you're dealing with a person with the onset of dementia or Alzheimer's, where they may be going into their own account to their own detriment, spending the money, squandering it inappropriately, giving it to someone that was preying on them. So that is something to be mindful of. Power of attorney does not limit the person that granted the power of attorney. Thank you. Diving deeper into the power of attorney. Exciting. Yesterday, I discussed the fact that if I give a power of attorney to someone, it doesn't limit what I can do. So if I permit a person, I'm the principal and I give them the title of agent, they can take actions and efforts on my behalf. They can step into my shoes financially. So if I permit someone to be my agent and give them the ability to access my bank account, it doesn't mean that I lose the ability to go into my bank. I want to be clear on that. However, the ability I give them, the authority that I give them is temporary. It's at will while I have capacity. So if I'm alive, well, alert, fully capable of thought and reasoning, I can cancel the power of attorney. I can revoke it. I can give that person notice, call them on the telephone. I could place it in writing and say, January 1, I had given you my power of attorney, or I had granted you, I had made a power of attorney. And now today is, this is not real life. Today, June 1, I'm revoking your power of attorney. Effective immediately, you can no longer take actions or effort or behaviors or conduct on my behalf through this document. I am revoked. So the authority that I give the person is temporary while I have capacity in most powers of attorney. If there was a durable power of attorney and I have, or I become incapacitated, well, then I probably can't revoke that power of attorney without someone going to court. So for a person that is pre-Alzheimer's or dementia, pre-cognitive condition, they make a power of attorney, they create it, they authorize someone to be their agent, and subsequent to that, after that, they become incapacitated. The power of attorney remains in force and effect. It remains active and cannot be revoked by the person if they have this incapacity. That's the legal word for not having the cognitive ability to be able to decide their own actions and behaviors and things like that. Now, if someone involved in the family can't be, in my example, can't be the person that has this incapacity. It's got to be another loved one, maybe a close family friend, a spouse, an adult child. If they thought the power of attorney should be revoked because it was being used impermissibly, well, then you'd have to go to court in the guardianship arena to revoke the power of attorney. I went far afield. What I was trying to say for us of this video is the power of attorney is subject to the person making. If you need any questions answered, please take a look at my website. I guess don't call me. Read the website first, frankbrunolaw.com, but certainly call if you need any questions answered.